Support comes from Missouri Forest Products Association, committed to sustainable and sound conservation of the state's forests, which support more than 41,000 Missouri jobs, resulting in a $10 billion industry. ChooseWood.com.
Welcome to St. Louis on the Air. I'm Sarah Fensky.
Yeah, y'all know what it is. Katy Perry.
Katy Perry's hit song Dark Horse was everywhere a few years back, peaking at #1 on the Billboard streaming charts in January of 2014. But for St. Louis-based gospel rapper Flame, the song wasn't just an earworm, it was a ripoff. Believing Perry and her collaborators had blatantly stolen from his song Joyful Noise, he sued them for copyright infringement. Last month, he won a $2.8 million jury verdict. Joining me in studio to talk about this case is Mike Kahn, senior counsel at Capes Sokol Law Firm in Clayton, and adjunct professor at Washington University School of Law, who won the verdict on Flame's behalf. We're also joined by Micah Zeller, head of scholarly communication for Washington University's library and a copyright expert. Micah, welcome to the program.
Thanks for having me.
Mike, first, congratulations to you.
Thank you.
Can you give us a brief overview of what your client's case here was?
Sure. So there is a term that I didn't know in the music world called an ostinato, which I got to know over the last 5 years quite well. An ostinato is a repeating refrain, usually 8 to 10 notes, usually two measures. It repeats over and over and over again throughout the song. And those who have heard Joyful Noise, which was the Christian gospel hip-hop song that was at issue here, that is this ostinato that repeats. And my client, who Flame, Marcus Gray, this was back in 2008. The song was released. It was the #1 hit for them. It was a Grammy-nominated song. And he's performing around the country. And in 2013, he has fans coming up to him at these concerts asking him if he sold the rights to his song to Katy Perry. He even had a couple of bookers in churches who would be booking concerts who were very concerned because they felt that this Dark Horse song was the antithesis to a Christian gospel song, and they were concerned about even booking him. He didn't even know what the song was. And he went online and he listened to it, and he was surprised and hurt.
Because he saw clear similarities there.
Yeah, and, you know, as I explained to the jury in the opening statement, this is a case about taking something valuable without permission. And that's what copyright infringement is all about. So the case was filed 5 years ago here in St. Louis. It was transferred to California. It was a long and arduous slog for my three clients, not just Marcus Gray, but the other two writers. And they were seeking justice from a jury of their peers, and we're pleased that they got it.
They ended up being victorious there in a big way.
Yes.
Let's, for our listeners, let's show them how these two songs sound. We're just going to play the beginning here. Let's start with playing the beginning of Dark Horse. This is Katy Perry.
Yeah, y'all know what it is. Katy Perry, Juicy J. Let's rage.
I knew you were gonna come to me. And here you are, but you better choose carefully. 'Cause I'm capable of anything, and everything.
That was Katy Perry's Dark Horse, which was released in 2013. Now let's listen to Joyful Noise, which St. Louis rapper Flame released in 2008.
You know what it is. I love it. Yeah. I love it. Let's talk about it. Your boy's been a Christian quite a few years. Victory and faith, but I failed in my fears.
And that was St. Louis artist Flame, with his song Joyful Noise, which predated Katy Perry's hit there. I gotta say, as somebody who doesn't know much about music at all, these two do sound a lot alike. Micah, is that enough for a lawsuit?
certainly in this case,
That's true.
it
The proof is in the
was.
pudding.
The focus again was on this portion of the musical backing track, this descending ostinato figure that you hear throughout Joyful Noise and then in the verses of Dark Horse. Now, not all musical elements are copyrightable, and not all copying is infringement. And so there are a number of specific things that you must prove in order to prevail in a case like this. And so an important first question is whether this specific combination of musical elements is protectable. Music consists of lyrics, rhythm, pitch, cadence, melody, harmony, a number of different elements. So does this specific combination, as in Flame's Joyful Noise, give rise to being protected? Once that's been established, then you're looking at whether the defendants had access to the material. So there were questions on whether Joyful Noise was broadly disseminated, whether the defendants had the reasonable opportunity to have actually heard the track. Once that's established, then you move on to decide whether the two portions at issue are substantially similar. And that's also a very difficult question. These are hard questions for the jury to answer. With that, you're looking at a lot of testimony from different experts where they're doing an analytical dissection of those elements, and so saying what's common in both the tracks, what's not in common in both of the tracks. And then you move on to a more subjective inquiry where, from the perspective of a reasonable listener, are the two works substantially similar?
Okay. Here's a brief statement on the matter from Perry's lead attorney, Christine LaPera, on behalf of the Dark Horse writing and production team. Quote, "The writers of Dark Horse view the verdicts as a travesty of justice. There is no infringement. There was no access of substantial similarity. The only thing in common is an unprotectable expression, evenly spaced C and B notes repeated. People, including musicologists from all over the world, are expressing their dismay at this." Mike, I see you smiling. I'm sure that's not the first time you've heard that lawyer make that argument. What's your response to that?
Yeah, I mean, she says it's a travesty of justice. I would correct that. I think it's a triumph of justice. She may talk about these so-called musicologists around the world. Her musicologist, who had a huge music library, was unable to come up with a similar ostinato. He found 6 notes that he told the jury were the same, and his example was a song called Jolly Old Saint Nick and a second song called Merrily We Go Along, which is the same melody as Mary Had a Little Lamb. In closing argument, since he didn't play either one for the jury, I said, ladies and gentlemen, let me play you these two allegedly substantially similar songs. And I will tell you, the jury was laughing as they listened to the two of them.
Because they don't sound like Dark Horse.
No, they're nothing like Dark Horse. The music industry has been issuing doomsday predictions for as far back as the invention of the player piano. This is before phonographs and records, and the music industry made all their money from, selling, notated things people could play on the piano. They've been issuing, when the blurred lines came down, they issued all these doomsday predictions. We've been hearing these forever. The music industry, Katy Perry and the rest of them are doing just fine. And we look forward. As I explained to my clients, this is only round 10 in a 12 or 15 round boxing match. I'm sure they will file all kind of post-trial motions and take appeals. But they had 9 members of the jury listen to the two songs and concluded that they were substantially similar. And they listened to our musicologist, who's Professor Todd Decker, head of the music department at Washington University, and they clearly believed him. So
you guys each had an expert, and your
Yes.
expert is saying these two are really similar.
Oh, yeah, and he went through not just the music notes, but he went through 6 other factors. The timbre, the tone, as Micah mentioned, the fact that this is a descending ostinato in a minor key, which is very unusual. And, frankly, there are lots of 8-note ostinatos or harmonies that are very simple and very recognizable. In my closing argument, I sang the beginning of Beethoven's Fifth.
This sounds like quite a closing argument.
Yeah, for the jury. That's 8 notes. It's maybe the most distinctive 8 notes in all of music, and it couldn't be simpler. So.
And you're saying if that is something that should be protected, why not your client's
song? I use before they objected, I used the example of the 8-note repeating refrain in the Rolling Stones' Satisfaction, which is, if you look at it transcribed into notes, is simpler than the one in Dark Horse or the one in Joyful Noise, and yet it's immediately recognizable.
Yeah, so 8 notes is a big deal here.
Yeah.
Micah, it does feel to me, just as a layman, that there has been an increase in these kind of cases lately. Maybe it's just that there's an increase of them being covered in the news. But with, for example, the Blurred Line case, that resulted in a $5.3 million jury verdict. Are we seeing an escalation after that case came down?
I think it's hard to say. Again, I'd be hesitant to draw any broad conclusions from the outcomes of a few cases. As Mike can attest, it's not cheap to file these suits. And there aren't that many songs that gross $40 million as Dark Horse did here. And so I worry more about chilling the creativity of the artists and composers who don't have the clout and power of artists like Katy Perry. For difficult questions like this, I think it can be helpful to ask what's the fundamental purpose of copyright law to begin with. And again, we're trying to balance the rights of creators with the rights of the public. And the public, again, is who the law is ultimately intended to benefit. And so striking that balance is an area of robust debate. And cases like this do raise the question of, do we want to give people the power to exclude others from using, parts of our relatively narrow music vocabulary?
That was Micah Zeller of Washington University Libraries. We're also talking to Mike Kahn, an attorney at Cape Sokol in Clayton, who recently won a big jury verdict against Katy Perry. We've got a question from one of our listeners for Mike. Simon writes, how large was the Cape Sokol team, and who were the team members that worked on this case, and how large was the opposing side? I wonder if Simon works at your law firm.
I don't think so.
No.
Yeah, I mean, we referred, pulling on our client's Christian gospel background to the David versus Goliath nature of this case for them versus all these defendants. There were 3 of us from Cape Sokol on the team, and there were probably 10 to 12 lawyers on the other side from 2 very large law firms.
And they got this moved to their home turf. You were
Right.
there in Los Angeles. You guys must have had a considerable outlay to keep this case alive and to go all the way to trial. Were you surprised that they didn't settle this thing, or did they try to settle this thing?
There, towards the very end, there were settlement discussions. There's an old joke when you say this is not about money, it's about principle. It's really about money. But for our clients, it was really about principle. They almost didn't care about the money part of it.
Really?
They felt that they'd been mistreated, and they wanted their day in court. And I even told them, I said, we can settle this case if you'd like. You won't get that much, but you'll break even.
You'll get a payday, yeah.
And they said, no, you know what? We want to go in front of a jury. We want a jury to hear our case. We don't care about the money. And so it was an unusual David versus Goliath battle here.
That is very unusual. I know part of the lawsuit was that Perry's song irreparably tarnished Flame's Christian message through its use of satanic imagery. Was that a big part of why he was willing to fight this?
I think it was, although the defendants were adamant to get that portion excluded from the jury.
Were they successful in
And
that?
yeah,
Oh.
they were. I mean, this was a copyright case, so you're allowed to seek damages. But there was a dispute, and the judge eventually ruled that portion should be excluded. And it was out there more in the music video, which was very controversial. There was a big protest by a lot of people from the Muslim religion, because there were some symbols there where this character in the music video gets blown up by Katy Perry, and he happened to have an Allah symbol around his neck. But ultimately, for our clients, the issue was more this was something that they created, and somebody should have talked to them to get their permission before they used it.
Micah, any sense of, since this obviously will be appealed by Katy and her team, what might end up being at issue on appeal here, or what the judges there might care about that maybe weren't as much in play at trial?
I think Mike might be better positioned to speak to the disposition of the judge in this case and the disposition of the defendants. Again, I do commend him for his work on this case. They faced a very well-funded and a highly motivated defense, and so this was an uphill battle, and they secured a terrific outcome for their clients. There's still a motion pending before this court, I believe, of whether a reasonable jury could have found this as a verdict based on the evidence presented. And again, these present really hard questions for juries. The tests can be confusing, and juries are made up of people, and so they're meant to resolve questions impartially, but we all have sympathies. And so I can't predict how this will proceed, but I think it's difficult to second guess the decision of a jury if you're not there to actually view and to evaluate all the evidence that is presented.
Mike, what do you think is going to be the hardest thing to retain on appeal?
Well, I think the focus will be, as I say, there's always doomsday predictions.
And there certainly have been with this case.
And the doomsday prediction that I think they will press the hardest is what Mike had mentioned, which is the issue of access. In order to prove infringement, you have to prove copying. Mm-hmm. And in order to prove copying, since you never have direct evidence, you never have a defendant said, I'm sorry, I did copy it. You do it through circumstantial evidence, and it's two parts. One is the thing Micah mentioned, which is, are these substantially similar? But you can independently create something that's substantially similar. So the other issue is, did the defendants have access to this song before they created theirs? And we tried to prove access in different ways. The song was nominated for a Grammy. At the time that Dr. Luke, who was the main producer and who's always bragged, he's been sued for infringement but never found guilty. He's not going to be able to make that brag anymore.
Nice.
But then we had the evidence that there were, between YouTube and MySpace, there were over 6 million views. They argue, and this is part of the doomsday prediction, that 6 million views is nothing. There are hundreds of millions of views out there. This is nothing. We tried to explain to the jury, look, 6 million is actually more than the population of the city of Los Angeles. It's a lot of people. But I think that's going to be an argument they're going to try to make, saying, oh, my goodness, now everybody who gets more than 100 views is going to be accessed. But we'll see.
But 6 million views, that's a lot more than 100. Did it come up at all that Katy herself used to be in this gospel scene, and that's where your client is doing his work?
Yeah, they were very careful. We mentioned that to her. We got her to admit that on stage, that her first album, when she was known as Katy Hudson, was actually a Christian gospel album. And she said that she stopped being Christian and stopped doing that work in 2002, and she didn't listen to that music anymore. So we didn't make a big deal out of it. Mm-hmm. She was telling the truth. But it was a fact that, ironically, she comes out of a Christian gospel background herself.
And now has gone in this very occult direction with her song, to the horror of your clients.
Right.
Mike, just one last question. I know you've had a couple of other really high-profile cases. You seem to get all the local cases that have a celebrity connection. Can you tell our viewers just a couple of them that you've been involved with?
Yeah, it's not something that I've ever sought out. So I get called out of the blue one day by this tattoo artist, Victor Whitmill, who's very upset because he saw an ad for Hangover 2, and the tattoo that he'd put on Mike Tyson's face shows up on the face of another person. So we ended up, and it was a copyright dispute, and we filed a lawsuit for that, and we got a very nice settlement for Victor. He's no longer a tattoo artist. Wow. And when I was a young lawyer in Chicago, we represented Michael Jackson in a copyright case, and Judge Marvin Aspen was the judge. We thought it was really nice. He said, I know that Mr. Jackson, there's all this, craziness with the press. I've arranged for the marshals to bring him up to my chambers through the back area. We thought, what a nice thing to do. And, of course, he was led into the judge's chambers where his 2 teenage daughters were waiting for him, and got to spend a full 45 minutes all alone with Michael Jackson. But, yeah, most of the cases don't involve people like that. But sometimes you get them.
That was Mike Kahn, lawyer to the stars, and also senior counsel at Cape Sokol Law Firm, and Micah Zeller of Washington University Libraries. Thank you both for joining us today.
It was a pleasure.
Thank you.
Support comes from the Missouri Forest Products Association. Missouri produces wood pallets, railroad ties, white oak barrels, hardwood floors, and more. Details on the variety of products made in the state are at choosewood.com.